I think we're now ready to resume. Mr. Crowe.
Thank you, my lord. Still on the subject of whether Section 8 of the Constitution of Bermuda it carries with it a right essentially to demand from the state recognition under the civil law of marriage for same-sex couples. We just wanted to draw to your attention a couple of cases which are mentioned, picking it up now at page 1279 of our printed case, paragraph 92. And we have two contrasting cases of Lee and Asher's baking and then Williamson. Lee and Asher's baking, as you may recall, was the case where a baker declined to honour an order for a wedding cake with the message support gay marriage on it. And the question therefore arose whether or not that involved discrimination under the legislation applicable in Northern Ireland. If we pick up the judgment, it is at, it starts at page 3273. Excuse me. And the issues are identified at page 3286. Paragraph 1 of the judgment, the substantive question in this case is whether it's unlawful discrimination either on grounds of sexual orientation or on grounds of religious belief or political opinion for a bakery to refuse to supply a cake iced with the message support gay marriage because of the sincere religious belief of its owners that gay marriage is inconsistent with biblical teaching and therefore unacceptable to God. If the prima facie answer to either question is yes, then questions arise as to the rights of the baker and its owners to freedom of religion and freedom of expression. And if we can then go straight to page 3294, where Baroness Hale for the Supreme Court said right at the bottom of the page, having said in paragraph 1, excuse me, that the issue was whether there was discrimination on grounds of political or religious belief. In paragraph 40, right at the bottom, she says 3 questions therefore rise on this aspect of the claim. Did the bakery discriminate against Mr. Lee on the grounds of his political opinions by refusing to supply him with a cake iced with this particular message? And then various consequential questions. And the only paragraph that we think will assist you, my ladies and my lord, is paragraph 41, where Baroness Hale says, as already mentioned, the Court of Appeal did not find it necessary to answer the question. The district judge held that support for gay marriage was a political opinion for this purpose. There was a political debate going on in Northern Ireland at the time about whether same-sex couples should be allowed to marry in Northern Ireland, as they are in the rest of the United Kingdom. The Assembly had debated a motion calling for same-sex marriage 3 times over a period of 18 months and had rejected it for a 3rd time only the week before. Political opinion is not defined in the legislation. In Mackay, it is defined as an opinion relating to the policy of government and matters touching the government of the state. It was said that the type of political opinion must be one relating to the conduct of the government of the state or matters of public policy. There is no need for an association with a particular political party or ideology, although no doubt that would also count. I see no reason to doubt that support for gay marriage is indeed a political opinion for this purpose. Now that, in our submission, is an important passage. It doesn't, of course, say in terms that for that reason a belief in same-sex marriage is necessarily not protected by the ECHR equivalent of Section 8 of the Bermuda Constitution, the freedom of conscience under Article, excuse me, Article 9 of the European Convention. It doesn't say that in terms, but the rationale for why which we've just read in our submission explains why, being a political opinion, a belief in what the law should confer by way of legal recognition on same-sex couples can't be a matter of conscience that is protected under another provision. And we contrast that decision in Lee and Asher's Bakery with the case of Williamson. I don't think we need to go to Williamson just for us to explain essentially what we get from it. Williamson, as you may recall, was the challenge that was brought by teachers and parents who sent their children to, or attended and worked at schools, private independent schools, which believed firmly, with biblical foundation, in the need to apply corporal correction to children in order to instill the fear of God when appropriate. And legislation had been brought in by the government abolishing corporal punishment, not just in state schools, which had long since gone, but even in private schools, even where the parents had chosen specifically to send their children to those schools for, among others, that reason, that the corporal punishment was to be administered when appropriate. Now, in relation to that, self-evidently, a belief, one can hardly imagine a belief that more closely attaches to the rights protected in Bermuda by Section 8, to manifest one's own religious belief by bringing up one's own children according to the strictures of your own religious belief. So the fact that the belief in Williamson is protected by Article 9 in ECHR terms, or would be by Section 8, is a reflection of the fact that the belief in question was fundamental to the practice by the individuals of their own religious faith, part of which is bringing up your own children in that faith. And so in our submission, the contrast between those two outcomes in the English case law illustrates the point of distinction on which we seek to rely to explain why the respondents' beliefs in this case don't fall within the protection of Section 8. Now, there is also then, if we move on in our written case at page 1280, there's a string of Strasbourg case law, none of which is particularly lengthy or detailed, but worth looking at. Before turning to the Strasbourg case law, could we just make one sort of footnote point? My learned friend's written case relies on a decision called Lendor and the Attorney General for Trinidad and Tobago. I don't ask you either to go to his case or to the authority at the moment, but just for your note, this is cited by my learned friends in paragraph 49(5)(c) of his written case at page 1330, and the decision in Lendor is at page 3310. The reason my learned friend cites the case is in support of the proposition that Bermuda does not necessarily have to follow the case law of the European Court of Human Rights. Now, there is a measure of agreement between us in that plainly the courts of Bermuda and this board does not have to follow to the letter the case law of the European Court of Human Rights in Strasbourg. But Lendor is not an appropriate sort of prism through which to view that principle, because what was being said in that case was that the ECHR, the European Convention on Human Rights, had been applied in I think the very late 1950s or early 1960s to Trinidad and Tobago, when it was still what was then called a colony. And the United Kingdom was responsible for its international relations. The rationale in the decision in Lendor as to why essentially Trinidad and Tobago could row its own boat in relation to human rights was that it had since then become an independent state. It had entered into its own international obligations with regards to human rights. And the United Kingdom was no longer responsible for its international relations and the United Kingdom did not guarantee compliance with the ECHR rights in Trinidad and Tobago. So for that reason, because Trinidad and Tobago was no longer, so to speak, within the ambit of the ECHR, it was for that reason that ECHR case law was to be discounted. None of that is true in relation to Bermuda. Bermuda is a jurisdiction in respect of which not only is the Constitution closely modelled, or the human rights elements of the Constitution are closely modelled on the European Convention on Human Rights, but it remains a British overseas territory in respect of which the United Kingdom is responsible for its international relations. And so the clear water, so to speak, between Bermuda and the ECHR case law is nowhere near as clear and wide as between Trinidad and Tobago. So we just wanted to make that point before turning up the case law on which we do rely from Strasbourg on this narrow question whether or not Article 9, as it is in the European Convention on Human Rights, protects a belief that the state should provide in civil law for same-sex marriage.
Can I just clarify, Mr. Crowe? You're not saying, are you, that the ECHR applies to Bermuda, are you? Or are you?
Sorry, I'm sorry, Marol. I may have misspoken. Can I come back to that? I'm sorry.
Yeah, yes, certainly.
Harry is the first. It's the first authority, my lord. It's in. It's on page 3854. And your lordship, my ladies, may be familiar with this one or not. The factual situation was that there was a married couple between people of opposite sex. The husband underwent gender reassignment surgery and applied for a gender recognition certificate. An interim certificate was issued, but not a final certificate, because the domestic legislation at the time provided that the marriage would have first to be annulled in order for a final certificate to be issued. So it was through that factual route that the question of whether or not Article 9 could be engaged in relation to a belief in what had then become same-sex marriage. And if we pick it up, the judgment starts at page 3854. And if we just pick it up at 3858, you'll see that the first issue is dealt with under Article 8 of the Convention. And to save me coming back to it later on, you'll see from page 3860, you'll see that under the court's assessment, what the court is saying is that the question whether or not there's been a breach of the right to respect for private and family life at the top of page 3860 calls to be examined by reference to question whether the state has failed to comply with a positive obligation to ensure the rights of the applicant through the means chosen to give effect legal recognition to gender reassignment. In this context, the notion of respect, as understood in Article 8, is not clear-cut, especially as far as the positive obligations inherent in that concept are concerned. It involves, as he says, a balance in determining whether or not a positive obligation exists. Regard must be had to a fair balance that has to be struck between the general interest of the community and the interests of the individual, the search for which balance is inherent in the whole convention. I just wanted to park that thought so that we don't have to come back to this case. And then over the page at 3861, in domestic law, marriage is only permitted between persons of opposite gender, whether such gender derives from attribution at birth or from a gender recognition procedure. Same-sex marriages are not permitted. Article 12 of the Convention similarly enshrines the traditional concept of marriage as being between a man and a woman. And then it goes on in the next paragraph to say the court cannot but conclude, therefore, that the matter falls within the appreciation of the contracting state. The passage actually dealing directly with Article 9 is on the next page, and it's very short. Page 3862, second paragraph. The court notes firstly, as regards Article 9, that the provisions do not purport to regulate marriage in any religious sense, and that it depends on each particular religion, the extent to which they permit same-sex unions, the matter in which the state chooses to grant its own formal legal recognition to relationships does not, in the circumstances of this case, engage its responsibility under this provision. So it's a short, but it's an extremely clear statement that Article 9 does not cover this particular belief. And one gets more of the same, again, very short rulings. There's an early decision called X and Germany, which you will find at page 5461. And you'll see, just take the facts from the head note on page 5461. The applicant complains that German authorities don't recognise his marriage to Mrs. Y. The registrar of marriages refused to make an entry in the family record because the applicant had not married under the forms prescribed by Section 11. The applicant complained to the district court, which had rejected it, and the court held that the right to marriage as guaranteed under the Constitution only referred to the conclusion of a marriage in the form provided by the legislator. And since he hadn't married according to the locally applicable rules, then the marriage was not to be recognised. The complaint under Article 9, again, is dealt with shortly and none the worse for that on page 5462. Where it says it is true that Article 9(1) of the Convention secures to everyone the right to freedom of religion. However, in this case, this provision cannot be considered without having regard to Article 12, which provides that men and women of marriageable age have the right to marry and found a family according to the national laws governing the exercise of this right. Marriage is not considered simply as a form of expression of thought, conscience, or religion, but is governed by the specific provision of Article 12, which refers to the national laws governing the exercise of the right to marry. Now, as I'm sure my learned friend will point out, the ruling there that a claim to a right to marry does not fall within Article 9 is decided partly in conjunction with the fact that the right to marry is expressly conferred by Article 12 of the European Convention on Human Rights. And that's an entirely fair point for what it's worth. But the fact is that what the European Court is saying, and in our submission, consistently with other case law and consistently with logic and consistently with the language of the Article 9 right, which is on which Section 8 of the Constitution of Bermuda is closely modelled, is that marriage is not considered simply as a form of expression of thought, conscience, or religion. And although shortly stated in our submission, what that embodies is the logic of the argument that we have urged on you, which is that what Section 8 of the Constitution protects is individual acts of worship or observance, not beliefs that extend, in a sense, a right to demand of the state the recognition of a legal status. Just going back to our written case, page 1281, we have the next case is Johnson and Ireland. I won't go to that. The case reference is there if you want to look at it. It was analysed more directly in the judgment as being a complaint about the absence of divorce, rather than the situation was that because Irish law didn't provide for divorce and a man and wife had separated, the man then could not marry a person of his choice. So on one view, it's closely analogous to our case because it is a complaint about the absence of the ability to marry, but the reasoning is expressed more by reference to the absence of the availability of divorce. So it's possibly not the case that most assist you. The fourth and final one that we just wanted to draw to your attention is Khan and the United Kingdom, which is at page 2998. Again, very brief, but the principle can be stated briefly, and as I say, it's none the worse for that. So Khan was the case in which a man claimed to be entitled, as no doubt he could say, that he was entitled under Islamic law to marry a Muslim girl of 12 years without her parents' consent, which is what he did. He was then prosecuted here, I think, for abduction and also for sexual relations with an underage girl, and he complained about that conviction. If we just pick up the ruling at page 3000, where the Strasbourg court says it's true that Article 9 secures to everyone the right to freedom of thought, conscience, and religion, and to manifest their religion or belief in worship, teaching, practice, or observance. However, the term practice, as employed in Article 9, Para 1, does not cover each act which may be motivated or influenced by a religion or belief. While the applicant's religion may allow the marriage of girls at age 12, marriage cannot be considered simply as a form of expression of thought, conscience, or religion. And again, the words on which my learned friend would no doubt rely, but is governed specifically by Article 12. The fact that it is specifically governed by Article 12 under the ECHR, and that Bermuda's constitution does not have an exact equivalent of Article 12, does not mean that Section 8 suddenly expands, because Section 8, modelled as it is on Article 9 of the ECHR, cannot be considered simply as a form, Section 8, modelled as it is on Article 9, protects the right to profess and manifest your religion, and marriage is not considered simply as a form of expression of thought, conscience, or religion. So those Strasbourg cases provide support for our proposition. And the counter is that there is absolutely no case law supporting the opposite proposition, supporting the proposition that Article 9 of the ECHR protects itself a right to demand from the state same-sex marriage. So the case law supports us. There is an absence of case law supporting my learned friend. If we can move on, page 1282. We simply observe here that more generally there are decisions which take a rigorous approach to what Article 9 protects. And as essentially the point we wish to urge is that you don't get yourself within Article 9 of the ECHR simply by saying, I believe in something that's very, very important to me, and I want to do it. Because essentially that was the argument in Pretty. Pretty and the UK. Diane Pretty, you may recall, was suffering from the terrible illness of motor neurone disease, progressively debilitating to the point where she was paralyzed in all limbs, wanted to die at a moment of her choosing, wanted to have her husband help her die in a dignified way at a moment of her choosing, and wanted, entirely understandably, to make sure that her husband was not going to be prosecuted for the offence of assisted suicide if her wishes were respected. And her claim was founded partly on Article 9, and it fails. One can hardly imagine. Obviously, human relations, marriage, foundation of society, extremely important, but one can hardly imagine a more important belief than a belief in the ability to leave one's life at a moment and in a manner of one's choosing. And yet the gravity of the belief, the seriousness of the belief, the seriousness of the issue which it engaged was not such as to bring it within Article 9. And if we just look very briefly, the report is at page 4014. And the relevant section dealing with Article 9 begins at page 4053. And the court, as it always does, sets out the article, it sets out the parties' submissions on behalf of the applicant and then the government. And then at paragraph 82, it says this: the court does not doubt the firmness of the applicant's views concerning assisted suicide, but would observe that not all opinions or convictions constitute beliefs in the sense protected by Article 9 of the Convention. Her claims do not involve a form of manifestation of a religion or belief through worship, teaching, practice, or observance, as described in the second sentence of the first paragraph. As found by the Commission, the term practice, as employed in Article 9.1, does not cover each act which is motivated or influenced by a religion or belief. To the extent that the applicant's views reflect her commitment to the principle of personal autonomy, her claim is a restatement of the complaint raised under Article 8. The court concludes that there's been no violation of Article 9. And the court could have expressed that conclusion as saying that Article 9 wasn't engaged, because there was no question of considering justification or interference. There plainly was interference if the belief fell within the protection of Article 9. So what one gets from that is that genuine meaning has to be given to the words worship, teaching, practice, and observance. And in our submission, those words cannot be stretched by judicial divination to include a right to demand of the state legal recognition of a same-sex marriage. Going back to our case at page 1282, we mentioned two more cases finally under this heading as to whether Article 9 Section 8 of the Constitution protects the beliefs in this case. We mentioned in paragraph 95 the case of Larimore. Larimore, you may have seen reference to more than once in our cases. It was the case involving another religious right case involving a convert to Islam who was required to I think I confused the cases. I just got it.
Soldier who was required to attend parade and
Yes,
doff
it is. Yes, it is.
during prayers.
Yes, yes, and remove his cap. There originally had been a dispensation, and then the dispensation was withdrawn. The only reason we cited, and I don't need to turn it up for this, the only reason we cited is to give some colour to the meaning of freedom of conscience under the Bahamian Constitution, which is essentially identical in this respect to the Bermudian Constitution, which refers where Lord Mance describes freedom of conscience as being, in its essence, a personal matter. It may take the form of a belief in a particular religion or sect, or it may take the form of agnosticism or atheism. And it's the concept of a personal matter that resonates in our submission with the what we describe as being the unilateral nature, the autonomy that is respected in the concepts of observance, practice, and manifestation. Simply for completeness, we also mention Attwood Sterling and the Attorney General in paragraph 96 of our case, because that is the one Bermudian case where this particular provision has been considered, but we mention it for completeness, not because it adds anything to the learning on this particular point, simply because conscientious objection was accepted without argument as falling within the protection of the provision. And in our submission, that's entirely understandable, perhaps even inevitable, because it related to the personal acts of the individual, whether he did or didn't participate in service in the armed forces. So there's no reasoning in the Attwood Sterling case that particularly assists this board in understanding the scope of Section 8 of the Constitution. Before leaving that, because I won't have a huge amount of time in reply, could I just give some headline responses on 4 cases that my learned friend has cited in his case, so that he knows what I say about them and he can respond, and then hopefully my reply will be shorter. He refers, first of all, to the case of Steinfeld. I think we can get through all of this without actually turning any of them up. If I just describe what the issue is as we see it and why we say you get no help from any of these cases. So Steinfeld is, just for your note, at page 4702, and it's referred to in my learned friend's case at paragraph 45, page 1325. And he seeks to rely on Steinfeld in support of his proposition that the respondent's belief in same-sex marriage falls within the protection provided by Section 8 of Bermuda's Constitution. Our response is that argument simply doesn't hold water. The issue in Steinfeld was an argument that the availability under UK law of both marriage and civil unions to same-sex couples, but the availability of only marriage, but not civil partnerships to opposite-sex couples, involved discrimination. So, and discrimination contrary to Articles 14 taken with 8 of the European Convention on Human Rights. So there was no reliance on Article 9 of the Human Rights Convention at all. So my learned friend can't tease out of a case on discrimination any support for the proposition that the belief on which his clients seek to rely falls within Article 9 of the ECHR, or by extension Section 8 of the Bermuda Constitution. The second case my learned friend seeks to rely on is a US case, Obergefell and Hodges. And that, again, I think we can deal with without going to. I'll just explain what we say about it. So that is cited by my learned friend at paragraph 46 of his case, which is page 1325. And the report is to be found at page 3649. Essentially, the point, I mean, and in fairness, I think to my learned friend, he cites this in support of the proposition that the respondent's beliefs, in his words, are serious and far from trivial. Now, that I have conceded, and I'm happy to emphasize that we entirely recognize that the respondent's beliefs are serious and far from trivial. If that is all he seeks to get from the American judgment in Obergefell and Hodges, then I have no issue with him. If one does go to it, if one seeks to take from that, however, an assertion that therefore the beliefs are protected by Section 8, of course, we would say that's a non sequitur, because the test under Section 8 is not seriousness or gravity, it's whether the nature of the belief is one that is protected by that provision, and whether the hindrance is with a manifestation or practice of a protected belief. If one then turns up this US case, you will see that in any event, the debate is not being conducted by reference to any provision which is analogous to Section 8 of the Bermuda Constitution. The debate was conducted by reference to the due process clause in the US Constitution, which had already been interpreted as embodying, because it is about individual personal development, it had already been interpreted as including a right to marry. So the question then was, well, does it also, therefore, include a right to marry as between same-sex couples? And the majority said yes, but not by reference to any analytical approach that assists you on working out whether or not the beliefs that are in play in this case are beliefs within Section 8 of the Bermuda Constitution. It may also illuminate, or not, to look at there are some powerful dissents, starting at page 3676. Again, I'm not going to ask you to turn them up now, but they do contain an interesting exposition of one aspect of the argument that we have been urging, which is the difference between objecting to interference by the state on the one hand and demanding action from the state on the other. And so I would simply draw those to your attention for that purpose. Third case a learned friend seeks to rely on is the Law Society of British Columbia against Trinity Western University. And that is his case, written case, paragraph 49(3)(b), which is page 1328. And the judgment itself is at page 3078. And again, I think we can probably get through my explanation of why it doesn't assist you without actually turning it up. The issue in that case was that the Trinity Western University was applying to be recognized as running a law college. It required its students to sign up to a covenant not to indulge in sexual relations outside the sacred bond of marriage, because it was an evangelical college and the teachers and its students subscribed to the belief that it was important to their spiritual development to have their higher education conducted in an environment which respected their religious beliefs and encouraged those practices. And it may just be helpful if I just read to you a brief encapsulation of what the evidence showed. I'm just reading, I don't ask you to go to it, but I'm reading from para 73, where the court says, to summarize, it is clear from this evidence that evangelical Christians believe that studying in an environment defined by religious beliefs in which members follow particular religious rules of conduct enhances the spiritual growth of members of that community. And the covenant supports the practice of studying in an environment infused with evangelical beliefs. So those were the religious beliefs that were held to fall within the scope of the protection of religious conscience legislation in Canada, and that being the nature of the beliefs that fell within the scope. They are, in our submission, uncontroversial. The finding that is a protected belief is uncontroversial and not illuminating for you in relation to the question that you have to decide, which is whether or not a belief that the state ought by civil law to recognise marriage is a protected belief. And the fourth and final case I just wanted to deal with, that my learned friend seeks to rely on, is another Trinidad and Tobago case, Sanatan Dharma Mahasabha, which he cites in his case at paragraph 49.3c, page 1328, and the judgment is to be found at 5188. I don't ask you to go to it, but again, absolutely nothing that assists his case, or indeed the argument in this appeal, appears from that case. It was, in the event, an extremely recondite issue. What the case originated from was a legal challenge for the name of the highest award that could be given in Trinidad and Tobago. The order it was called the Trinity Order, Trinidad obviously being Spanish for Trinity. So Trinity Order was the award, and the highest rank, so to speak, in it was called the Trinity Cross. And the point was taken that calling it a Trinity Cross, leaving aside the word Trinity, which is part of the name of the country, calling it the Trinity Cross was discriminating against Muslim and Hindus and infringed their religious rights. That was conceded by the Attorney General for Trinidad and Tobago. The argument in the Privy Council turned on a very arcane point as to whether or not the court could or could not make a declaration that the establishment of the award was unconstitutional when it was done, which entirely turned on a very technical question as to whether or not the letters patent establishing the award were or were not an enactment within the meaning of the Trinidadian Constitution. There is nothing in the judgment that discusses what is the content of a belief protected by an equivalent to Section 8 of the Bermuda Constitution. So, with the greatest respect, in a case in which, as I say, the Attorney General conceded that there was a discrimination, and it was discrimination that was complained about, and steps were being taken to rename or reconstitute the award, one is getting absolutely nothing from that case at all. So I just wanted to rattle through those four cases which Melanchthon seeks to rely upon before returning to our case. And if we can pick it up at page 1283, we have covered the initial question now, are these beliefs protected? The next question is simply whether, if they are protected beliefs, whether there is any hindrance with the enjoyment of the belief. The points that we make in that regard are something gone wrong with the numbering of our case, but at the top of page 1284, we've gone from subparagraphs to paragraphs, but matters not the content. But the observations we make there are that the legislation in question does not prevent anyone from participating in a ceremony of marriage, whether as a couple or as a celebrant. We say in 102 it would be artificial to ignore the fact that Section 53 forms part of a broader legislative package designed to provide a detailed legal regime by which same-sex couples can enter into a formal union. And thirdly, we say, to repeat the point we made at the very beginning, the corollary to the foregoing is that Section 53 concerns the label of marriage for legal purposes only. And the only case that we wanted to draw to your attention in this context, and it's a matter of taste whether one looks at Halpern either in terms of what is a protected belief or by reference to whether there is any hindrance. But we did want to draw your attention to the decision in Halpern, which is another Canadian decision, and it's the judgment begins at 2555. And it was a case dealing with the question whether the unavailability of same-sex marriage interferes with, among other things, a person's freedom of conscience. And the circumstances of the case were that various same-sex couples and a church, the Metropolitan Community Church of Toronto, applied for declarations that the inability to register a same-sex marriage under Canadian law, or the law of Toronto, involved discrimination and interference with religious rights under Article 2A of the Canadian Charter, which is essentially equivalent to Section 8 of Bermuda's Constitution. So there are issues of discrimination, and there are issues of interference with religious rights. So, and it's in relation to the latter, obviously, that we will need to pay some attention. The issues you will see identified at page 2571. And if we can pick up the, so to speak, Section 8 point, Section 8 of the Bermuda Constitution, at Section 2A of the Canadian Charter at page 2578. I just wanted to draw your attention to, the whole of the next sort of 2 or 3 pages are worth reading, but just for the purposes of oral submission, if I could draw your attention to paragraph 53. In our view, this case does not engage religious rights and freedoms. Marriage is a legal institution, as well as a social, religious and social institution. This case is solely about the legal institution of marriage. It's not about the religious validity or invalidity of various forms of marriage. We do not view this case as in any way dealing or interfering with the religious institution of marriage. And then over the page, paragraph 58, MCCT, that's the church, also argues that the common law's failure to recognise the legal validity of the same-sex marriages it performs constitutes a breach of its right to be free from religious discrimination under Section 15 of the Charter. So this is the discrimination claim builds onto the interference with religious belief claim. We consider the impact of Section 15 on the common law definition of marriage in greater detail in the next part of these reasons. For now, it appears clear to us that any potential discrimination arising out of the differential treatment of same-sex marriage performed by the Church is based on sexual orientation. This differential treatment is not based on the religious beliefs held by the same-sex couples or by the institution performing the religious ceremony. for this reason, we conclude that NCT has failed to establish religious discrimination under section 15. And I just wanted to read that now because it saves me coming back to the case when we get on at the very end to section 12 of the Bermuda Constitution. But for present purposes, it's paragraph 53, again shortly stated, but none the worse for that, that the claimed belief in the need for legal recognition under the civil law to same-sex marriage does not fall there within section 2A of the Canadian Charter, which is, as I say, equivalent to the Bermudan section 8 of the Constitution, the protection of freedom of conscience. That brings us on, my ladies and my lords, to page 1286 in our case, where we say this, and I just wanted to pick it up because we've touched on this already, but I just want to put it in context. We say at 106, not only did the Court of Appeal wrongly fail to recognise the significance of the decision in Halpern, it also misunderstood the relevance of the Canadian decisions in Big M Drug Mart and Saguenay and the Bahamian judgment in Larimore. Those were all cases involving overt acts by the state. Furthermore, Big M Drug Mart and Larimore involved overt acts of compulsion by the state. And I've taken you to those, to the relevant provisions in the passages in those judgments when addressing you on the initial question as to whether or not there's a religious purpose rule. I don't need to go back to them, but you'll recall the discussion in each of those cases about the compulsion mandating compliance with a sectarian Christian ethic and so on. And similarly, the wording in paragraphs 82 to 84 in Saguenay, which considered the effects, the positive effects in creating a public space that was antithetical to the atheist beliefs of Mr. Saguenay. So that deals with the question whether there was any hindrance with the relevant beliefs. That brings us to the third aspect of Section 8, which is whether or not the, if there is hindrance, whether or not it can be justified. And your Lordship's already indicated that you're minded to hear the argument on this de bene essay and decide, if you need to decide, whether to take into account or not. I will therefore be relatively light on whether or not you should decide the point. Essentially, we submit something similar, but not identical, happened in the Williamson case, the corporal punishment in private schools case, because in that case, the Secretary of State had run an argument on justification at first instance. He got soundly kicked and didn't press it in the Court of Appeal at all. In fact, overtly abandoned the argument in the Court of Appeal. It wasn't argued at all. It then comes up to the Supreme Court or House of Lords, and the Secretary of State asks to revive the argument. That is opposed, partly on the grounds that the respondents would have wanted to adduce evidence. And Lord Nichols for the court said that the issue should be decided, partly because it was undesirable for the issue to go, in a sense, half undecided. If the question of the validity of the measure was only going to be partly decided, it would plainly not be in the public interest because it would need to come back to be redecided later. That public interest argument in favour of your ladyship and your lordship deciding this point under the umbrella of this appeal is entirely valid. It would be undesirable if the point were left hanging. the other question is, well, would it involve any further evidence? My learned friend adduced substantial, or his clients adduced substantial evidence at first instance from an American academic, from clerical ministers, from individuals, from a cruise operator, and your Lordships and your Lordship may note, just picking up page 1288, the very top of page 1288, we make the point in paragraph 112.1 that at first instance, before the trial, the Chief Justice held a case management hearing and gave a case management ruling, which I'm not sure he had a hearing. Anyway, he certainly issued a case management ruling saying that one of the issues likely to be determined was justification. And the concern he expressed, and you'll see this at page 172 if you turn it up, the concern he's expressed was not that learned friend Lord Panic's clients had not put in relevant evidence, but that the Attorney General had not adduced any responsive evidence. So the concern was not that my learned friend's clients were deprived of an opportunity to put in relevant evidence on the issue of justification, but that the Attorney General hadn't answered that evidence. Now, the Attorney General is in front of this board, keen that the issue should be resolved, and is not suggesting that any relevant evidence, any further evidence needs to be adduced. And my learned friend Lord Panic, in his case, has not identified any evidence or any categories of evidence, and he's not asking for an adjournment to adduce any evidence. And when one looks at the arguments that he is mounting in response to justification, they are just legal arguments. And so in our submission, yes, it is late in the day for the point to be taken, but it causes no prejudice, and it is in the public interest that the issue should be resolved once and for all. So for those reasons, when you come to consider the point, we will ask you to rule on it if necessary. Now, as I say, the answer that my learned friend gives does not depend on any evidential or the absence of any evidence. His arguments are essentially legal. And the first point he takes, and it may be convenient just to look at the way he puts it, in his case at para 76, it's page 1341. And he says at para 76 at the bottom of 1341, the appellant has failed to establish that the revocation provisions advance any legitimate aim under section 8.5. See the closed list of legitimate aims above. It's not good enough for the appellant to assert at paragraph 118 of her written case that the policy objective of section 53 is obvious, namely to secure and support the traditional, i.e. pre-Godwin, definition of marriage for legal purposes as a union between a man and a woman. Now, what my learned friend is then saying, if we look at section 8.5, which is on page 1474 in the authorities, section 8.5 at the very bottom, page 1474, says nothing contained in or done under the authority of any law shall be held to be inconsistent with or in contravention of this section, or to the extent that the law in question makes provision, which is reasonably required in the interests of defence, public safety, public order, public morality, or public health, or for the purposes of protecting the rights and freedoms of other persons, including the right to observe and practice any religion or belief without the unsolicited interference of other persons professing any other religion or belief, except so far as that provision, or as the case may be, the thing done under the authority thereof is shown not to be reasonably justifiable in a democratic society. So essentially, my learned friend's argument is that an argument of justification fails because there has been a failure to identify the legitimate public interest which is being pursued. That, in our submission, is an ambitious argument because it raises the question of how any claims in Strasbourg objecting to the absence of same-sex marriage in any particular state could have failed. And the reason we say that is this, as we have partly seen, and we'll see again very shortly, the various claims that have been made in Strasbourg complaining about the absence of same-sex marriage have been advanced either on the basis of Articles 8 or 12, embodying a positive obligation to provide for same-sex marriage, or have been advanced on the basis of a breach of Article 14, taken with Article 8 or 12, namely discrimination. Whichever way the argument has been put, as you will be familiar, the way the analytical tool that the Strasbourg court uses in order to decide whether or not a positive obligation exists and has been broken, and whether any differential treatment can be justified, the test that is applied is to consider whether a fair balance has been struck between the rights of the individual and the interests of the community. So if upholding a conventional view of marriage was not in itself a legitimate objective in the public interest, then nothing would have been available to put in the balance on the other side of the equation, and it's difficult to see how the Strasbourg cases could have been decided as they were. Before turning to those cases, though, I just did want to touch on the point that my Lord Reid mentioned earlier, which is the references in a considerable number of cases from different jurisdictions to the traditional definition of marriage as being a union between two persons of the opposite sex. For this purpose, I did just want to turn up a couple of cases very briefly. The first is the US case that I've mentioned once already. That's Obergefell and Hodges. That starts at page 3649. And I just wanted to draw to your attention a passage at 3658.
This case is notable for probably the rudest opinion ever written by Justice Scalia.
Yes, I wasn't going to indulge myself by reading that bit. But,
No, the connoisseurs of invective.
For the court, Justice Kennedy, in the very foot of page 2593, right-hand column, says, from their beginning to their most recent page, the annals of human history reveal the transcendent importance of marriage. The lifelong union of a man and a woman always has promised nobility and dignity to all persons without regard to their station in life. Marriage is sacred to those who live by their religions and offers unique fulfillment to those who find meaning in the secular realm. Its dynamic allows two people to find a life that could not be found alone, for a marriage becomes greater than just the two persons. Rising from the most basic human needs, marriage is essential to our most profound hopes and aspirations. The centrality of marriage to the human condition makes it unsurprising that the institution has existed for millennia and across civilizations. Since the dawn of history, marriage has transformed strangers into relatives, binding families and societies together. And we then get references to Confucius and Cicero, just in case anyone might thought that marriage is a sort of Judeo-Christian piece of copyright property. And he then goes on to say there are untold references to the beauty of marriage in religious and philosophical texts spanning time, cultures, and faiths. It is fair and necessary to say that these references were based on the understanding that marriage is, a union between two persons of the opposite sex. And we get some similar observations from Lord Nichols in Bellinger, which again we've mentioned but not gone to. If we could just turn that one up, which is page 1971. And just look briefly at page 1982, where I would commend to you the whole of, I'm not going to read it obviously, but the whole of paragraphs 34 to the bottom of 49, so those 3 pages. But I just wanted to pick up on page 1984 at paragraph 46. He says, even in the context of marriage, the present question raises wider issues. Marriage is an institution or relationship deeply embedded in the religious and social culture of this country. It is deeply embedded as a relationship between two persons of the opposite sex. There was a time when the reproductive functions of male and female were regarded as the primary raison d'etre of marriage. And then he goes on to quote from the Book of Common Prayer. And then at 47, he says, against this background, there are those who urge that the special relationship in marriage should not now be confined to persons of the opposite sex. It should be possible for persons of the same sex to marry. This, it is said, is the appropriate way to resolve the problem, such as those confronting Mrs. Bellinger. It hardly needs saying that this approach would involve a fundamental change in the traditional concept of marriage. Here again, this raises a question which ought to be considered as part of an overall review of the most appropriate way to deal with the difficulties confronting transsexual people. For these reasons, I would not make a declaration the marriage celebrated between Mr. and Mrs. Bellinger in 1981 was valid. That was a marriage I should have introduced, but it was a situation where a man, a person, sorry, who had been born a man, underwent gender reassignment surgery to become a woman. As a woman, she married a man in 1981. With respect, I would suggest that Lord Nichols is making 3 important points in this passage. First of all, obviously, that marriage is a deeply embedded concept as a union between an opposite-sex couple. Second, that marriage is not just a religious concept. But thirdly, also, that the courts, because of the wide-ranging social policy implications, the courts should be slow to legislate for an answer. There are a couple of other cases I'll need to be relatively brief with. Wilkinson, we opened our written case quoting from Wilkinson. If I could just urge that, commend that one to you. I won't go to it now, but it's page 5325. And I would invite your attention to paragraphs 45 to 47 and paragraph 116. One case I do want to go to is re Close, which is page 4903. Under the Northern Irish law at the time, a same-sex couple, may still be the case, I'm not sure, a same-sex couple could enter into a civil partnership, but not a marriage. And 2 same-sex couples brought a claim for judicial review to quash the provision limiting marriage to opposite-sex couples. And if we could pick it up, the ratio of the case starts at page 4917. And I just wanted to draw to your attention on 4919, paragraphs 51 and 51 and 52. As the trial judge recognised, there has been a clear trend towards providing legal rights and recognition for same-sex couples who wish to form long-lasting relationships. Although other countries had already started along that path before the UK, there was still some ambivalence about the entitlement of such rights in the Council of Europe. Looking at the period between 2004 and 2014, it seems clear that the aim of the exclusion of same-sex couples from marriage was to acknowledge the historical nature of marriage as a commitment between a man and a woman, which had an embedded cultural significance for those who had entered into it. And I won't read it, all of that, but just picking up at paragraph 52, saves me coming back to it. What the court then says is, having regard to the package of measures for same-sex couples introduced under the 2004 Act, the controversial social policy issue involved, the views of the Assembly, the absence of evidence of broad support in Northern Ireland for a different approach to the rights of same-sex couples during this period, and the position in the Council of Europe, we consider that during this period the fair balance was struck. So what we get there, and I'm anticipating the later parts of the argument, but what we get there is both a recognition that upholding the deeply embedded historic traditional concept of marriage as a commitment between a man and a woman was the objective that was being pursued, and what was taken into account in regarding that measure as being justifiable included the fact that a package of measures was available, which we have under the Domestic Partnerships Act, the fact that it's a controversial social policy issue, obviously again applicable, the views of the Assembly, again you get that in our case through the passing of the Domestic Partnerships Act, the absence of evidence of broad support for a different approach, you get that from our referendum, and the position in the Council of Europe where there is still no suggestion that Article 9 embodies a right to same-sex marriage. My ladies and lords, the Strasbourg case law I will have to deal with very likely, but could I just suggest that the three cases that will help you most, we've already seen the first, so I don't need to go back to it, which is Parry and the United Kingdom, and the relevant passages there are pages 3860 to 3862. The second case that I think would assist you most is Schalk in Austria, which is page 5208. And we would commend to you paragraphs 61 to 63, which are page 5221. And finally, the decision in Orlandi, which is at page 3788. And we would commend pages 3831 to 3833. In the interest of time, I can't obviously read through those. So we say that there is a good basis for saying that there is a legitimate objective to be pursued in upholding a deeply embedded tradition of marriage as a union between opposite-sex couples. And having taken you to read close, I can deal with the rest of the argument under this heading, relatively likely. I'm now on page 1291 of our case. And we can pick it up we're now at paragraph 121. running through the different criteria for justification, assuming one has a legitimate objective. Is the measure rationally connected to the objective? Self-evidently so. Whether a less intrusive measure could have been used, we submit self-evidently not. It is a binary choice. You either do or you don't define marriage as a union between opposite-sex couples. So one is then left with the balancing exercise. The only point I just wanted to dwell on in relation to the balancing exercise is that my learned friend's case asserts that the Strasbourg concept of a margin of appreciation under which the Strasbourg court defers to national choices in legislation has no role, he says, in relation to a domestic court's assessment of domestic legislation. That is sort of true, but only true in terms of labelling. The margin of appreciation is indeed the label that is applied to the attitude the Strasbourg court takes when it is expressing deference to the national choices of national legislation or of national governments, recognising that different cultural and historical traditions exist in the different member states of the Council of Europe. But a very closely analogous principle applies, under which domestic courts recognise that there are certain issues, particularly issues of delicate social policy, on which the legislature is better placed to make the decision, and the courts should respect that. Now, this is not the argument that my learned friend would wish it to be, in the sense that he has referred to various cases which talk about the tyranny of the majority. The argument is not that the population of Bermuda is allowed to commit breaches of human rights because that's what they want to do. If you come to the conclusion that there is a violation of the human rights, which cannot be justified, then the fact that a majority voted against same-sex marriage in the referendum, and the fact that Parliament in Bermuda passed the legislation it did, is not an answer. But that isn't the argument that we're running. We're not saying that there is a violation, but you should somehow ignore. What we are saying is that when we have got to this stage of the analysis and you are considering justification, one of the elements in the question of justification is to take account of the local conditions in the particular jurisdiction. And that is what the margin of appreciation is also about. But it is also a recognition of what Lord Nichols was saying in the Bellinger case, which is that there are some issues of such delicate social policy with such ramifications that it is not appropriate for the court to substitute its own judgment for that considered judgment, which has been given by the legislature in passing express and, in this case, quite recent legislation. So we do say, and this is essentially, I'm speaking to paragraph 123 of our case. Your lordships and your ladyships will be familiar with the passages in Brown and Stott and with AXA, which make good these points, and the extra respect that is required in relation to particularly delicate issues. And the only thing I would emphasize in this regard is at the very top of page 1293 in our case, where we quote from the Countryside Alliance case. The democratic process is liable to be subverted if, on a question of moral and political judgment, opponents of the Act achieve through the courts what they could not achieve in Parliament. And that is, in our submission, a salutary warning in a situation where out Bermuda, as you saw at the very beginning of my submission, positively supported the compromise, but is now trying to use the legal process to achieve a different result. Just on the tyranny of the majority point, one of the passages my learned friend relies on in that context is Baroness Hale in Re G, paragraph 122, I would simply invite you to look at the paragraph before, paragraph 121. I'm not going to ask you to go to it, but it is a paragraph which recognises the need to give consideration to the particular circumstances in the jurisdiction in question, evidenced by its own history and, in this case, by its legislative choices. Not because they are unimportant, but simply because we have nothing to add to them. I wasn't going to speak to paragraphs 1 to 4 or 1 to 5. I've essentially given you the argument that we wanted to advance by way of the background and the very careful and conscientious consideration that was given in Bermuda to the production of this compromise solution. And in our submission, that is an important part of whether or not this board should set that compromise aside by excising one significant part of it. So for those reasons, in relation to section 8, we submit it's not engaged. If it is engaged, there is no relevant hindrance. If there is a relevant hindrance, it is justified. Section 12, I can take very briefly indeed, discussed as well in view of the time. The provision itself is to be found at page 1478. And this is the only aspect of discrimination on which my learned friend has and can rely. Section 12 says, subject to the provisions of subsections 4, 5, and 8, no law shall make any provision which is discriminatory, either of itself or in its effect. And subsection 3 defines discrimination or discriminatory. In this section, the expression discriminatory means affording different treatment to different persons attributable wholly or mainly to their respective descriptions by race, place of origin, political opinions, colour, or creed, whereby persons of one such description are subjected to disabilities or restrictions to which persons of another such description are not made subject, or are accorded privileges or advantages which are not accorded to persons of another such description. And the very short points here are that, first, if you take the conjunction of the words wholly or mainly to their respective descriptions by creed, what is clear is that section 12 is aimed at preventing discrimination by saying a Jewish person is not allowed to hold public office. A Catholic person is not allowed to vote. A Seventh-day Adventist is not allowed to enter this recreation ground. That would be discrimination attributable to the respective descriptions of somebody by creed. Creed must mean a belief system. It's not just a single isolated belief. And in this respect, it's important to note that section 12 of the Bermuda Constitution is more muscular than Article 14, but it's narrower than Article 14. By that, what I mean is Article 14 prevents discrimination on the grounds of an awful lot of other things, including opinion. You don't get that here. It's creed, and it's discrimination by reference to descriptions by creed. So in our submission, it is quite clear that it is of narrow ambit. Its effect is more muscular because it's not parasitic on discrimination by reference to any of the other provisions. You'll know that Article 14 of the ECHR is not an entirely autonomous provision. You have to have a complaint that's within the ambit of one of the other convention rights, in order to complain about Article 14 discrimination. Section 12 discrimination is an entirely self-standing right, but it is a right that only operates if there is discrimination by reference to someone's description by creed. So the Court of Appeal was absolutely right to say simply having a belief in same-sex marriage and not being able to exercise that belief supposedly by entering a same-sex marriage is not discrimination by reference to your description by creed. So the first point is description and creed must mean discrimination by reference to a belief system. And the second point, which the Court of Appeal didn't really make, but we think with respect is an equally knockout point, is that the discrimination that you complain about has to be discrimination where there is difference of treatment attributable to the description by creed. And these respondents simply cannot make that case. They are unable to enter into same-sex marriages, not because they believe in same-sex marriages. They cannot enter into same-sex marriages because the law doesn't provide for them because they are of the same sex. So I can entirely see an argument that might have been made if discrimination on grounds of sexual orientation was available. And one can entirely see why, some years after 1968, it was considered appropriate to introduce a Human Rights Act that had a wider definition of discrimination. But that's off the table. So our answer on Section 12 is twofold, essentially. There isn't any discrimination on the basis of a creed because the complaint only relates to a single belief. But in any event, the discrimination is not attributable to the belief. It's attributable to the gender of the same-sex person who wishes to marry. And our final point, if we needed it, would be if there is discrimination, it would be justified by reference to the same arguments we've advanced in relation to justification under Section 8. I am 2 minutes over, but my lords, my lady, those are the Attorney General's arguments in opening.
Thank you very much, Mr. Crowe. There don't appear to be any questions for you at this stage. So I'll turn then to Lord Panic and invite him to begin his submissions.
Thank you very much, my lords, my ladies. Before dealing with the three legal issues that arise on this appeal, that is the religious purpose issue, the legislation's effect on freedom of conscience and religion, and discrimination based on creed, can I address some preliminary points which are raised by the appellant's written and oral submissions? The first one is that in the written submissions, and again today, my friend Mr. Crowe has said that this appeal, this dispute, this legal dispute, is concerned with a label. It's concerned with the label of domestic partnership or marriage. We say that this appeal is concerned with far more fundamental issues than that. It's concerned with the fundamental importance to the dignity and the self-worth of same-sex couples, of being able to enjoy the civil status of marriage, which is central to the culture and the society of Bermuda, as it is to that of the United Kingdom and most countries in the world. This is no rhetorical flourish, to use my friend's description this morning. It may once have been traditional, his word, near the end of his submissions. It may once have been traditional for marriage to be confined to man and wife, male and female, but no longer. In at least 30 countries of the world, same-sex marriage is recognised, in some of them as the result of legislative action, as in the United Kingdom, in others as the result of judicial decision. The United States and South Africa are examples. Of course, the decisions depend upon the particular constitutional provisions in those countries, and I'm not simply asking the board to transplant the reasoning, but it is a fact that traditional concepts, what were once traditional concepts of marriage, are no longer. And in any event, I would respectfully submit that constitutional law is replete with judgments which recognise human rights in contexts which had hitherto been contexts where those rights were denied for various traditional reasons. Tradition is no answer to a constitutional claim. If the board needs evidence on just how serious these issues are to those who are affected, I commend to the board the unchallenged evidence in the affirmation of the third respondent, Mary Ellen Claudia Louise Jackson, which is at page 842 of the electronic bundle, 842. It's paragraphs 2, 12 and 13 of her evidence, but I won't take time on that. I should also add, in the light of what my friend said this morning, that the significance of these issues is not simply the self-worth of individuals and the fact that they feel demeaned by being denied access to perhaps the most important social institution in society. There are also practical disadvantages that a partner may not be recognised in other countries, such as the United States. Again, there is unchallenged evidence on this subject from Professor Najim. In particular, it's bundle page 498. He's a tenured professor at Harvard Law School, and he talks of this. This is a particular problem in Bermuda, given its proximity to the United States. Many people there, of course, have experience, often sad experience, of medical issues causing the need for an airlift to the USA for treatment. I mentioned that. I should also mention under this first introductory point that since the Godwin decision, nearly 4 years ago, on the 5th of May 2017, many valid same-sex marriages have taken place, and they continue to take place in Bermuda. I should also mention that although Mr. Crowe lauded the achievement of Bermuda in being the first country, he said, in the general region, Bermuda's not part of the Caribbean, but including the Caribbean, the first jurisdiction to recognise same-sex partnerships, civil partnerships, Bermuda also has, and that's why we're here, the far less distinguished record of being the first jurisdiction to legislate to remove the rights currently enjoyed of same-sex couples to enter into a legally valid marriage. And that has significance when the board is considering particularly the questions under section 8 relating to effect, relating to hindrance and relating to manifestation, to which I I will come. That's the first preliminary point. The second preliminary point that I wanted to mention, if I may, is that it is a theme of the appellant's written case, and it was also a theme that was developed by my friend Mr. Crowe this morning, although he rode back from it a bit near the end of his submissions. But one sees at particular paragraph 9 of the appellant's written case. It's electronic bundle page 1252, if the board would please kindly turn it up. And it's a high octane submission, if I may put it that way. At the end of paragraph 9, page 1252, the last sentence, the effect of the Court of Appeal judgment is accordingly to reverse the democratic choice of the Bermudian people and to set aside the delicate political compromise which the Parliament of Bermuda has settled upon. Now, I do respectfully submit that the way in which the appellant there puts her case, and some of the submissions, not all, but some of the submissions that my friend made this morning, ignore the elementary truth, although elementary, it needs to be stated in these proceedings, that the Constitution of Bermuda confers on the board, as on the local courts, a duty to assess and to determine whether legislation has breached the rights protected in the Constitution. My friend referred rightly to section 34 of the Constitution, page 1403, which recognises that what he rightly describes as the plenary powers of the legislature are subject to the rights guaranteed by the Constitution. The courts, the board, has the function of ensuring that whatever the legislature does, it does not breach the fundamental rights which the Constitution has guaranteed. And there's a passage in the Reyes decision. My friend took the board to Reyes, Lord Bingham's judgment. Can I ask the board please to go back to it? It's bundle page 4956. And the relevant paragraph is paragraph 26, which the board, your lordships and your ladyship, will find on bundle 4967. And I will come back, if I may, to that page between C and E, which my friend read. But there's then a passage at F, just by F on page 4967, where Lord Bingham says, in carrying out its task of constitutional interpretation, the court is not concerned to evaluate and give effect to public opinion. Public, of course, very important. They express their views in a referendum. Less than 50% could be bothered to vote. So the idea that they're very exercised by this issue is perhaps an exaggeration. But the court is simply not concerned with popularity. That's not the issue in constitutional adjudication. That which the people may strongly approve of may nevertheless amount to a breach of constitutional rights. And that takes me to the third introductory point. Could I ask your lordships and your ladyship to keep open page 4956, the Reyes decision.
I'm afraid it's rather difficult for us to keep different pages open at the same time because of the screen.
That is perhaps one advantage of the paper bundles that I am using. I would suggest there are many advantages of the paper bundles. I hope that there will never be a hindrance to my rights to use paper bundles. Otherwise, there may be litigation on that. 4967. Could I take the board back, please, to paragraph 26? And it is in my submission important to see that what Lord Bingham said at paragraph 26 is not inconsistent. Indeed, I put it the other way around. It is consistent with what Lord Hoffman said, if I may say so, in his own distinctive style, in the cases cited by my friend, Mr. Crowe, the Matadine case, which was EB 3340, and the Boyce case was EB 2051. And it's consistent because Lord Bingham, for the board, refers to the wealth of authority around the world, and one of the cases is Big M, and I'll come back to that. And just above E, Lord Bingham recognises that the starting point is the language that is used. And that's very important. I'm not inviting the board to give free rein, to use Lord Hoffman's phrase in Matadine, or to ignore the language. The language is of vital importance. But, as Lord Bingham goes on to say, it would be wrong in principle, he says, to treat the language of the Constitution as if it were found in a will or a deed or a charter party. A generous and purposive interpretation is to be given to constitutional provisions protecting human rights. And the reason for that, in my submission, is that constitutional provisions, particularly of the sort with which the board is concerned in this case, are expressed in general terms. This is not the drafting of a detailed statutory instrument on a rating issue. It is a concept that is being enacted, that is being protected. And it is the task, with respect, it is the task of each succeeding generation of members of the board and of lower courts to give life and purpose and effect to those general provisions. And that's why, says Lord Bingham, of course, the judge does not read his or her own predilections and moral values, but is required to consider the substance of the fundamental right and ensure contemporary protection of that right in the light of evolving standards of decency that mark the progress of a maturing society. And if I have, and I do, an overarching respectful criticism of the approach of my friend, and it's a very forceful approach that he advances, it is that his approach seeks to narrow and confine the words of the Constitution by, with respect to an over-literal interpretation that does not adequately respect the need to look at substance and the need to adopt evolving standards and the need not to treat this language as if it were a will or a deed or a charter party. But I agree with him. The courts, the board, of course, cannot put this aside and say same-sex marriage is a jolly good thing, or indeed a jolly bad thing. And that is the answer to the issues. I should also add in this context, if I may, that one of the other reasons why constitutional guarantees of rights, such as those to be found in Section 8 and Section 12 of the Bermuda Constitution, are so generously interpreted by the use of the principles approved by Lord Bingham, is because in respect of almost all specified rights, torture of course is an exception, constitutions then contain sub-clauses or separate clauses which enable government and other public authorities to seek to justify their decisions and actions, notwithstanding the prima facie breach. And that is of vital importance in my submission when one seeks to interpret the scope of the prima facie right, because the thrust of my friend's narrow construction of Section 8 and Section 12 before he gets to justification is that he has to say that the prima facie rights in Section 8 and in Section 12 do not apply, however strong the religious or conscientious opinions are, however damaging it is to the substance of those religious and conscientious opinions for them not to be validated, and however unjustifiable the position of the state may be. That's how he has to put his case before he gets to justification. So I do submit that a generous approach to the breadth of the prima facie right is entirely justified. I rely on Lord Bingham, but I say it's entirely justified both by the nebulous nature of the right, it needs to be filled in, and by the fact that it is always subject to justification. That is, if the state brings forward a justification at the proper time, and I'll come to that. A further and final preliminary point I just wanted to mention concerns the decision in Godwin, the 2017 decision. Mr. Crowe indicated arguments which might, could, would have been advanced in 2017 had he been representing the state. But I hope I correctly understood my friend to indicate that he is not inviting the board to decide on this appeal whether Godwin was correctly decided. And we respectfully would agree with that. Neither his case on this appeal nor my case on this appeal depends on whether Godwin was correctly decided. It's part of the context, it's an important part of the context, because it was decided by the Supreme Court, that is the High Court of Bermuda. There was no appeal from the Supreme Court decision. The reason for that was that the then Attorney General took the view that it was, quote, correct in law, and he took the view there was, quote, no reasonable chance of a different decision on appeal. I take that from what he said. It's at bundle page 731. I should also point out that in the courts below, in the Bermuda courts, in these proceedings, the Attorney General did not take issue with the decision in Godwin, by which I mean did not ask for it to be declared wrongly decided. The Attorney General's position, the correct position in my submission, was that this was not material in any legal sense to the constitutional issues we're now arguing. The Attorney General's position was clearly expressed in written submissions to the Court of Appeal. I just give the reference. It's page 288, paragraph 3 Roman 2 and 295 paragraph 17. It's true that the Chief Justice expressed his views about Godwin, but the Court of Appeal did not. The Court of Appeal proceeded on the correct premise that Godwin represented the context in which the Act was passed, but no more than that. If relevant, and it's not, but if it were relevant, we would respectfully submit that Godwin was correctly decided. But I'm not asking the board to address that. I do not accept that the Tavares case to which my friend referred, bundle 5235, determines the issue. Tavares was focused on the immigration context in that case. It may assist in the 5 minutes that remain if I just begin my submissions on the first substantive issue, that is religious primary purpose. There are two parts to this question, as the board well understands. First, the question of law. Does a provision which has a religious primary purpose breach the right to freedom of conscience and religion? And second, the question of fact and judgment. Do the revocation provisions fail that test? And what I will seek to develop tomorrow, if I may, my lords, my lady, are our answers to those two questions. And can I summarise? I hope it's helpful just to summarise our position on the question of law. The force of Mr. Crowe's submission, as I understand it, is he says that Section 8, when you look at it, is effects-based. It requires a hindrance, and a hindrance looks to consequences. It looks to effects. He has various other points, which of course to which I will seek to respond. Now, our primary response to that question of law, which I shall develop, is this. We say that for the state to enact legislation in order to implement a religious tenet is itself a hindrance to freedom of religion. And the reason why that is so is because it means that people who do not share that religious view nevertheless have that religious view imposed upon their lives as part of the law of Bermuda. And we rely, and I'll take the board to what we say are the relevant passages, we rely on the Canadian jurisprudence, and we rely on the judgment of Lord Justice Laws in the McFarlane case, although of course I accept that he wasn't addressing the Bermuda Constitution. And I'll seek to develop that, if I may, tomorrow. Can I equally briefly just summarise our case on the facts? We accept that what the minister did was persuade Parliament to enact a compromise. But the compromise which the minister invited the legislature to enact was based, we say exclusively based, but at least primarily based, as to the impugned part, that's the revocation provisions. It was based on the religious objections in Bermuda to same-sex marriage. We say that this compromise was a compromise which accommodated, as to the impugned part, the religious viewpoint. There was no secular objective which the minister was advancing other than a compromise to accommodate the religious viewpoint. And we say, and I'll develop this if I may tomorrow, we say that this is a case, to use the phrase of Mr. Justice Dixon in the Big M case, it was a case where the minister, the government, acted, quote, at the behest, unquote, of the religious community. That's how I will seek to put our case on the facts tomorrow, if the board is persuaded that there is a relevant legal principle. That is, I think, precisely 4 o'clock. I hope that is a convenient moment. I will seek to develop those points, if I may, tomorrow morning.
Thank you very much, Lord Pennick. In that case, we'll adjourn now for the day and we'll resume at 10:30 tomorrow. Thank you very much.
Thank you, my lord. Thank you, my lady.